I now welcome representatives from the Defence Honours and Awards Appeals Tribunal. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For those at the table, could I please ask that you state your name and the capacity in which you appear today?
Stephen Skehill, I'm Chair of the Defence Honours and Awards Tribunal.
Jay Kopplemann, I'm the Executive Officer of the Defence Honours and Awards Appeals Tribunal.
Thank you both. Mr Skehill, would you wish to make an opening statement?
Yes, if I could, Chair, if you'll
please
grant me that indulgence.
Of course.
I thought it would be useful if I focus particularly on those aspects of submissions that relate directly to the tribunal, and then after that we're happy to endeavour to answer any questions on the broader terms of reference. In all the very many civilian workplaces that I've been engaged over 55 years, it's been common learning that morale, recruitment, productivity and retention is fundamentally affected by both the reality and the perception that there is a comprehensive, fair and transparent system for the recognition of commitment and performance. I think the submissions to the committee make it clear that the defence workplace is no different. And indeed, the degree of commitment involved in ADF service and the potential risks of ADF service to life and limb make the need for an effective and efficient recognition system all the more important. I think those submissions also disclose a significant degree of dissatisfaction with the present ADF service recognition scheme. Whether all that expressed dissatisfaction is accurate and justified may be an issue, but the very fact that there is that perception there is a reality that does need to be dealt with. There's a lot of dispute within the present system. The tribunal plays a vital role of dispute resolution in the present scheme. We're an independent statutory body. We've got two functions. Under our review function, a veteran, a member, a family member or another party can come to us to obtain an expert, thorough and merit-based analysis of a decision to refuse a defence honour or award. And under the inquiry function, the Minister can direct the tribunal to inquire into an issue relating to honours or awards, and those inquiries tend to be more systemic or policy-oriented or more general. They're not individual cases. Over the 14-year life of the tribunal, it's had around 500 review matters brought before it, and it's completed 30 inquiries which have considered the service of tens of thousands of veterans. There's a relatively small but nevertheless fairly constant and consistent stream of disputed defence decisions that are brought to the tribunal, where our task is to arrive at the correct or preferable decision after a merits analysis that ensures that both parties, those seeking recognition and defence that's refused recognition, that each receive a fair hearing and provided with meaningful and detailed reasons for whatever eventual decision the tribunal reaches. These matters can be sensitive and challenging. The subject matter can be highly nuanced and require careful expert analysis, and the veteran may be suffering from a mental health or other service-related medical condition which makes the handling of these cases all the more sensitive. Through both our functions, we believe we provide a valuable service to veterans and families through inclusion in the decision-making process and ensuring their voice is heard, to defence by remedying mistakes and fostering improved decision-making, and to government by providing the Minister with an independent forum in which he or she can obtain advice on difficult, sensitive issues. It's inevitable in these processes that there are winners and losers. Claims for recognition are either accepted or rejected. In those circumstances, the extent to which the Tribunal's decisions are a cause for complaint by those seeking recognition or by defence must be a measure of how well or how badly the Tribunal's performing. Looking first at submissions from members, veterans and their supporters, it's significant, I think, that notwithstanding the many hundreds of cases in which Tribunal reviews and inquiries have denied ADF members or veterans the outcome sought for them, amongst all the submissions lodged with the committee, only one review decision and one inquiry report are the subject of any direct criticism. This suggests the Tribunal has performed its role to a very high degree of satisfaction, and that its practices of personal engagement and detailed statements of reasons have allowed unsuccessful applicants to be ensured that they've been heard, their views fully considered, even when they're not accepted. The two cases to which I refer that are the subject of direct criticism, submission 39 from Mr John Hunt, that evidences his deep disappointment with the Tribunal process and decision. We rejected his claim that his service in Malaysia in 70-71 was warlike and concluded that it didn't warrant award of an Australian Active Service Medal. His claims were based on what he accepted were and stated as his recollections of what happened while he was in Malaya, and also on some theoretical possibilities of what might have happened. And none of his recollections or the theoretical possibilities were borne out by any documentation that we could find, despite the fact that we engaged in some very extensive research. Notwithstanding that we thought that there wasn't any factual basis, we did go on and considered whether, if his assertions and memories were correct, would his service have been warlike, and we concluded that it was nothing more than non-warlike. The other inquiry, the inquiry report that's the subject of direct criticism is the report into metallic recognition for service with Rifle Company Butterworth. There's a number of submissions, but principally submission 35. I have to say I believe those submissions are riddled with errors of fact and law, misrepresentations, misunderstandings and misconceptions. But the most fundamental thing about them, if the Tribunal had done what the RCB review group claims we should have done, RCB veterans would be worse off than they currently are, and worse off again than they would be if our recommendations were accepted. We think their criticism of our report is misfounded. So apart from those two specific cases, there's a few other things that are raised about the Tribunal. The Australian Peacekeeper and Peacemaker Veterans Association submission, number 41, makes a number of claims about alleged Tribunal processes and procedures which, if they ever had any validity, and I don't think they did, are certainly not reflective of the Tribunal today. It's a mature Tribunal and it does not follow the procedures that are alleged of us in that submission. And a number of submissions suggest that Tribunal members come to hearings with preconceived views and aren't prepared to contemplate contra views. I suggest that that's not the case and that those who make this claim have misunderstood the role and duty of the Tribunal, which is to give a party an opportunity to respond to any matter that the Tribunal believes to be relevant. So if we have a sense that there might be a contrary argument, we need to put that to the parties and give them the opportunity to dissuade us from that view. That's not having a preconceived idea or view. It's simply doing what the law requires of us. Of course, the successful performance of the Tribunal's role is necessarily dependent upon the collective and individual integrity of its members. Because of that, I think it's incumbent on me to draw to the committee's attention two submissions that make serious allegations of impropriety against individual members of the Tribunal. The Australian Special Forces Alliance submission suggests improper conduct by Tribunal member Brigadier Diane Galash while she was a full-time serving defence officer. And submission 56 from an unnamed submitter alleges that Tribunal member Rear Admiral Alan Dutoit should not have been a member of the Tribunal assigned to that particular case because it was said that he and a defence decision maker who represented defence at the hearing appear to operate closely with one another, potentially compromising impartiality. We value our propriety and integrity very highly. As a result, I inquired into both those allegations, and I can tell you that those inquiries show that each allegation is completely without any factual or other substance. Both Rear Admiral Dutoit and Brigadier Galash have my full support as Tribunal members of integrity. A number of other submissions express strong support for the Tribunal, and some seek an expansion of its jurisdiction and role, and perhaps we need to talk about that a little later. Turning now to the other side of the ledger, what does defence say about us? While the Tribunal very often agrees with the position advanced by defence, there are many cases in which we do not, and in some of these we're highly critical of the defence position. It's thus, I think, significant that the defence submission contains no criticism of any Tribunal decision or inquiry report. It's also significant that, so far as we're aware, in only 2 cases has the defence sought to prevail upon the Minister to reject a Tribunal recommendation for the bestowal of a defence honour or award. One resulted in the award of an honour at a lower level than that recommended by the Tribunal. The other was the now notorious case of Teddy Sheehan, in which the Tribunal recommended the award of a Victoria Cross for Australia. As is well known, that award was subsequently made after an ad hoc independent inquiry panel established by the government in the face of persistent criticism of the defence position came to exactly the same conclusion as the Tribunal. Given this absence of criticism of the Tribunal's decisions by defence, we think it's a matter of deep concern that the defence submission recommends amendments to the legislation underpinning the Tribunal that would significantly reduce or abolish existing rights of ADF members, veterans and their supporters to independent Tribunal review of adverse defence decisions. We've expanded on that in our supplementary submission to which the Chair made reference a while ago. While the defence submission in this regard is expressed in superficially moderate and benign terms, I think it's important that the committee understands the significance of these proposals, which the Tribunal unanimously believes to be incapable of justification. The defence proposals would render invalid the majority of applications for review that are made to the Tribunal. While defence seeks to curtail or abolish Tribunal decision-making, it proposes no corresponding limitation on its own ability to make adverse decisions on applications for defence honours or awards. Plainly, its purpose appears to be simply to render its own decisions immutable and unchallengeable, whether right or wrong, and without the transparency or accountability currently provided by Tribunal review. Worse than that, its proposals are illogical. The more complex the required decision-making as you go up the tree, of awards and honours, the more complex the required decision making, the more prone it is going to be to error, but the more defence seeks to remove such decisions from reach of tribunal review. And we think its proposals are completely counterintuitive. The more dangerous an ADF member's service, the more defence seeks to limit current rights of review. And worse again...
Could you say that again, please?
The more dangerous an ADF member's service, the more defence seeks to limit current rights of review. I can expand on that if you like.
Yes, please.
Okay. So you have medals like the Australian Defence Medal and the Defence Long Service Medal. To receive those, you simply have to have served for a period. Above those, you have campaign and operational medals. That's more dangerous service. And for those medals, Defence is trying, with these proposals, to cut back on the current rights of review. And then, worse again, where it's claimed that an ADF member has performed conspicuously or with distinction, gallantry or valour, Defence seeks to go even further and abolish current rights of review.
So if someone makes a complaint, they get their complaint removed.
They will not be
if they don't want to give the information to review special forces operations and stuff like that where it's dangerous.
Yeah. If the defence proposals were made law, we would not be able to accept applications. So let me put it in some fairly blunt terms. There'd be no VC for the next Teddy Sheen or the next Richard Norton. There'd be no Medal of Gallantry for Butch Swanton. There'd be incomplete and inadequate recognition for Sapper Rowan Conlon. You know, we can go through and all these cases would just be dead in the water. So one might be forgiven for thinking that Defence is simply trying to go back to the good old days when it could make recognition decisions with impunity and without any independent external overview. And that, regardless of the fact that ministers, governors-general, the late Queen and the current King have all accepted tribunal findings that Defence had got it wrong in refusing honours and awards. It's widely reported that Defence can't reach its approved strength, that its retention rate is as much a matter of concern as its capacity to recruit. Moreover, the Defence submission to the committee disclosed that only 6% of ADF survey respondents with low morale felt valued and recognised for the work they do at Defence, and only 2/3 of those with high morale felt valued and recognised. Notwithstanding these very sobering circumstances, Defence proposes the present capacity of ADF members, veterans and others to achieve the recognition they believe they warrant through tribunal review should be severely limited or abolished. We should be finding, recognising, respecting and celebrating our national heroes rather than confining them to obscurity or to inadequate recognition for their extraordinary service. I don't see how exhibiting such an apparent disregard for the recognition of deserving service can be helpful to Defence recruitment, morale or retention, and what damage it might do to the mental health of those who seek independent review to gain the recognition they believe they warrant doesn't bear thinking about. I therefore urge the committee to roundly dismiss these unjustifiable attempt to turn back the clock. Instead, I suggest that based on the submissions received by the committee and their lack of justifiable complaint, the committee can readily conclude that the tribunal has performed exceptionally well and should not be limited in its present role. But at the same time, I do want to stress that we don't claim to be doing things perfectly. We're not complacent. It's always possible to do better. Our primary submission to the committee details steps we've taken in the last couple of years to improve our processes and performance, and we'll continue to attempt to do better again in the period ahead. I should note that there are a number of submissions that you've received which refer to individual recognition issues that could potentially be reviewed by the tribunal if the submitter chose to make application to the tribunal, or if an application to defence was refused. There's also a range of other matters raised in submissions concerning collective recognition, and they could be referred to the tribunal for inquiry, and the committee might consider recommending to the minister that he should make such referrals. We'd be pleased to provide the committee with a list of such submissions if you wish. Can I just finish on a couple of things that came out of things that were said this morning?
Sure. If we could just keep it as short as possible, Mr. Skehill, because we do want to get to questions.
Sure. It was suggested that the tribunal was part of a Canberra cartel, a boys' club, that we just towed the defence line. We are, by statute, independent, and we take that independence very seriously. I suspect that if those who think otherwise read tribunal decisions and reports, they would see that we can and are in appropriate cases very critical of defence. We're not towing anyone's line. Scott Seacombe, in his evidence, referred to 5 case studies. We've not seen those. But he said that he'd appealed. We've never had an appeal from him. He talked about someone who had done 20 days service but been refused a Defence Long Service Medal. It's possible that if that was a decision taken by Defence some time ago, it would now get a different result. I say that because Defence used to convert part days of service to full day equivalents, and someone who had 20 part days might end up with less than 20 full day equivalents. More recently, following a tribunal decision, any day, whether full or part, of paid at defence rates of remuneration counts towards the 20. So that individual might well qualify. He also talked of another case of a woman, I think it was, who had, he said, served over 3 years but hadn't got
3 years and 9 months.
An ADM. That one I don't know anything about, but that is worth looking at. We'd be happy to liaise with you and your secretariat to get details and see if we can assist on any of those. You heard a deal about the recognition report today, and it's been mentioned by a number of people. I've got with me a few copies of the report which we can leave with you. If you want more, we can give them to you. But could I also just tender a one-page from that report, because I think it very graphically shows the issue with recognition of people killed, wounded or injured in defence service. Medals tell a story. People in service can look at someone's chest and know where they've been and what they've done. They read them like a book. But what those medals don't tell is what sacrifice the individual's done to render that service. They don't tell you whether that person, the owner of those medals, is killed, injured, permanently incapacitated, whether the medals are being held by a widow or a widower. And we think that sheet is just a very graphic representation of something that is lacking in the present system. The other thing I just wanted to mention, and there was some suggestion that the people and money in defence that deal with defence honours ought to be transferred over to the tribunal. I want to say to you, I think that's a very bad idea. It's bad for a couple of reasons. Firstly, I agree with Rear Admiral Bolton that recognising performance should be a core duty of leadership. It shouldn't, that recognition shouldn't be taken away from leaders. Secondly, if you put that function in the tribunal, we've got the capability, we've got the expertise, but what happens when we decide that someone doesn't qualify? We would have a massive conflict of interest. I personally think that function ought to remain within defence, but it needs work. But and there's a number of ways that the quality of that process can be improved. But if it's going to be taken out of defence, if anyone thinks that there has to be a separate independent statutory body, fine, set up another body, not the tribunal, because we would have a massive conflict of interest. So look, I've probably spoken longer than I should have, and I apologise for that.
That's all right. It's been very helpful. Thank you. I might just start with a few questions just about the tribunal itself, if I might, and then I'll pass to my colleagues. How many members sit on the tribunal? Okay, so there's we're at our statutory maximum of 10 plus the chair. And do you convene a full panel for every hearing? Or? No. Most depends on the issue, but mostly it would be 3 members. If there's particular complexity, might be 4. Okay. Recently, I convene a panel of 5. The other thing that was said that by one of the submitters that we should have more lay members, or we should have lay members. We've got 2 lay members. Myself, I've got no service background. The Act says I can't have previously performed continuous full-time defence service. And we have a former magistrate who has no defence service. And having 2 lay members there who can ask the stupid questions that question sort of defence orthodoxy is I think good and healthy. If we were to have more under the current Act, we'd have to get rid of someone else. We try very hard to get a multidisciplinary mix of people with senior defence experience and less senior defence experience, law, public administration and military history. And I think we've got a pretty good balance. In recent times, these positions have been advertised. There's been a public recruitment process, and we really have quizzed people about their suitability. We've been
overwhelmed by the quality of people who've applied. It's been tremendous, and obviously we couldn't appoint everybody who was perhaps worthy of it. So, but we've tried to pick the cream, and personally, and I'm old enough to, I think, be a fairly decent judge. I think we've got a great bunch of members, and I'm very honoured to be amongst them.
And who has I'll just get through a couple more questions. Who has standing to bring a claim before the tribunal?
Anybody, so long as they were an applicant to defence for an honour or award, and anybody can apply to defence for an honour or award.
Okay. So and you only have jurisdiction to review applications for awards that are not progressed or rejected by defence. You don't have jurisdiction to review awards that defence has already issued. No. Correct?
No one can appeal to us against the grant of an honour or award.
Yep.
But having said that, under the law at present, if there was thought to be significant concern about awards or honours that had been granted, the Minister could direct us to conduct an inquiry into that matter.
Mm-hmm. And your decisions are themselves reviewable by the Federal Court under administrative law grounds?
On a question of law, not on a question of fact.
Not a question of fact, okay. And then just in terms of your decisions, I was looking at your tribunal review outcome statistics, which you have in your submission. So you've got a category decision affirmed, which means you obviously affirm defence's decision not to grant an award. Decision set aside, does that mean you void defence's decision and it needs to go back to first instance, or can you actually grant an award yourself as a tribunal and overturn defence's decision?
No, we can't grant. We can, and it's different as between honours and awards. Mm-hmm. For awards, we can set aside the defence decision and substitute for it a recommendation that the award be given, and the Governor-General or a delegate gets that recommendation and acts on it. For an honour, we cannot set aside a defence decision, but we make a recommendation to the Minister, and we can recommend that the defence decision not be adopted and that the Minister should recommend to the Governor-General or the Sovereign.
Okay. And then this category, you've got application withdrawn following defence action, 72 since 2008. What's the garden variety of that? Is this like a settlement out of court? The defence decides to actually reconsider the application on its merits? Or?
I guess they probably fall into a few categories. But let me say that I think it's great when defence does concede and give an honour or award that's where they've previously refused. It might be that the individual has come forward with new evidence that defence didn't previously have. It might be that defence has looked again at the evidence they already had and come to a different conclusion. It might be that the tribunal, that defence has had regard to conclusions reached by the tribunal in other cases involving the same issue. So I mentioned that one about whether days on part payment qualify towards the 20 days per annum. So there's a group of circumstances in which defence might concede, and that's great.
And in your view, because this came up before, I mean, you exercise full independence and control over the operations of the tribunal. You've never had anything that defence has never sought to compromise your independence or influence your decision making.
No, and I noticed Senator Roberts' ears pricked up when he realised that our funding comes through defence. Never any suggestion that it'd be cut back or anything. Defence has behaved with propriety in that regard, and I wouldn't expect anything different going forward.
All right, thank you. I just wanted to get that on the record. Senator Roberts, would you like to?
Yeah, thank you, Chair. Thank you for appearing today. I've got a note here. You may remember that I asked Mr. Bolton to annex your C, and what would happen if we drew the line at Captain. Then we'd have 56 people with the Distinguished Service Cross above and only 2 below. And the same applies to, by rank, the totals, 292 of people who are majors or higher, and only 277. And yet the numbers below a major would be far greater than the numbers above major. So does that ring any alarm bells? This is all the medals and awards, Gallantry, Distinguished Service Cross.
There's lies and statistics. And I don't think you can come at this purely statistically. There's different categories of awards and honours with different eligibility criteria. And when you're talking about an award that is for distinguished leadership or command, you're not going to see that given to sappers, privates, junior NCOs. When you get to gallantry, it's different. You can have gallantry up and down the ranks.
That's what I was trying to get at with Mr. Bolton, but he put a red herring in the way. I said, it depends where you draw the line.
Yeah, but
okay, drawing the line at Lieutenant Colonel would seem to me to be ridiculous. That's a distortion. So if you draw the line at Captain, and he agreed with that, then it becomes a different picture. But if you look at the Distinguished Service Cross, as I said, 56 versus 2, and then I note a patrol commander can also be a sergeant or a corporal, one of the enlisted ranks. Distinguished command and leadership.
Yeah.
And a corporal can lead people in action, as a sergeant can lead people in action. So that would seem to be a red herring entirely with the response I got.
I don't want to agree or disagree on red herrings, but I think it's clear that in certain circumstances very junior members can lead.
And command.
Command might be a bit more difficult to establish, and there's been some cases at the Tribunal about that. I'm not sure that there's yet sort of a definitive statement that I could make to you in that regard.
Thank you. You've been here all day, so I commend you for that.
Yeah.
Thank you so much. You've been listening. You've been actively involved.
It's fascinating.
Yeah, maybe not if you're one of the people who are whinging it and complaining rightly. But we had accusations, complaints about people who believed that the top ranks were getting out of proportionally higher awards. And when we look at a realistic line, and we look at the number of people in the population below the line and above, the data would suggest that that's overwhelmingly true.
Well, as I said to you, I don't want to comment on the statistics because I don't think they're necessarily the definitive way of looking at it.
I put it to you that it is, but that's just a discussion then. You mentioned that culture is extremely important.
Yep.
And that people must believe that it's fair. For culture to be effective, it needs to be fair. That people must feel that they're being treated fairly, transparently, in regards to the system for recognition.
Yep.
I'd agree entirely. Culture is the most important, most powerful driver of behaviour in any entity, whether it be a football club or a CWA or school or parliament. You mentioned sensitive cases. No defence dissatisfaction. Defence wants to return to the days of sole responsibility. Why?
I don't think I said sole responsibility. I think I was suggesting that it appears from the proposals they're putting that they're trying to get out of accountability through tribunal review. Because they're arguing that so many fewer categories of cases should be appellable to the tribunal.
Right. I didn't mean to. What you did was you corrected the way I said it. That's correct. It just seems to me and to a lot of the people in this room and our witnesses that defence dislikes scrutiny. And same with Senate estimates. Defence dislikes scrutiny. Whereas a strong leader will love scrutiny because it'll show where he or she can improve. So defence seems to be afraid of scrutiny.
Look, I can't comment on that. I don't know what defence thinks in that regard. I noticed the defence said that this tribunal has no equivalent in any Commonwealth country. Well, I don't think there's anything turns on that. Australia has had a proud history of administrative review, external administrative review and accountability since the 1970s. And I think this tribunal is just part of that process, and it's a good thing. And if others don't have it, pity them.
My understanding is that the ratio of top brass to enlisted in Australia is far higher than any other country in the Commonwealth. So maybe that's why we need a tribunal, because there are too many chiefs.
I couldn't comment on that.
No. So what are your main insights that you've seen today?
Look, obviously there's a lot of emotion, there's a lot of concern.
What do you mean by emotion? Is it people just going off, or are you saying there's a lot of feeling in it?
It is a very emotional subject. I think that's clearly obvious. People value, and as they should, value recognition. It's a normal human condition, and people in defence, the same as in other organisations, want to be recognised and get upset when they're not. Now, whether...
Excuse me, is it the lack of recognition or the lack of fairness around the recognition system, or both?
Well, for some it's a lack of recognition. Mm-hmm. There are some people who have not been recognised but believe they should be, and there are some that don't think the process has enough transparency to satisfy them that their or someone else's recognition has been properly settled. And you heard a lot of suggestions today about having a system in which the initial nomination and the subsequent nomination and endorsement and any changes to it are all transparently maintained on a system. That I think is eminently good sense. So there's certainly that. The other thing that is apparent is that there are people who believe that some awards have been made that should not have been made, that were made illegally. Now, I'm not going to comment on that. I think it would be wrong and improper for me to do so. Wrong because you can only form a proper view about whether an award has been, or honour has been properly bestowed when you know all the facts of service and when you've had the opportunity to consider the law and form a view about it. And I don't know the facts of the cases that have been in contention today, so it'd be wrong for me to answer it. And with respect, I suggest that the committee doesn't know all the facts either. And it would be improper for me to go and venture a comment, because under the law as it stands, there is the potential that the tribunal could be asked to conduct an inquiry into these matters. And in that event, we would have to be able to bring to the inquiry an open mind, unfettered by any preconception.
I agree. In the case of General Campbell, though, there are two key dates, and everyone has known that for years. And defence keeps hiding it, keeps trying to cover it. So I'm not asking you to comment.
Okay,
I won't
comment then.
Anything else that you learnt today?
I was heartened by the expressions of support for the tribunal. I think we work hard to earn support and respect, and it's nice to hear that. What else?
Were you struck, as I was, by the competence of the first four in particular, as all the witnesses, but the first four in particular, and their message was quite consistent?
Look, I was struck by the various submissions that have been put to you, and I would say that they are thought-provoking. I say that as using it as a neutral term. That's not me saying they're right or they're wrong. I've got to keep an open mind.
Yep. Except
There are a couple of things in the Alliance submission where I think they've got it wrong. They talk about senior officers conferring honours on other senior officers. That's not how it happens. The Governor-General confers on the advice of the Minister. It doesn't go from officer to officer. But perhaps more significantly, there's a paragraph in their submission where they say that you can only get a distinguished award where your service is more distinguished than all your predecessors and your successors. Now, I think that's just wrong. The word most does not appear in the regulations. In other cases where the word most has appeared in the Victoria Cross regulations, tribunals come to the view that it's not an escalating eligibility criteria. What it means is your service has got to be up there. To say that it has to be the most, that everyone's got to be better than the predecessor, is like saying that an Olympian can't have a gold medal unless they've broken the world record. whereas we know they can get a gold medal for being the best on the day. And if you said, as that submission does, that you have to look at the performance of successors, then you could never award anyone a Distinguished Service decoration until the position was abolished, because we don't know how good their successors are going to perform. So, you know, there's an error, I think, there in the way or the standard they've purported to judge things by. That's not to say that they don't raise questions that require thought.
Thank you.
Senator Roberts. Senator Cadell.
Thanks very much. Going on to your point about some of the claims to move awards out of defence and some of the things you said around that not coming to you to keep your objectivity. What, of you and your 10 other board members, is there any security clearance, you know, positive, negative vetting or compartmentalisation to look at the more detailed active cases at that higher level?
Yeah, we've all had to have at least a basic security rating, and then if we needed access to something of a higher classification, then we'd have to limit access to whoever had that higher classification or get reclassified.
Really? So,
Can I just assist, Chair? Senator, there are a number of members on the tribunal with various different security clearances.
that's what I was trying to get. So, when were you saying that the higher you go up in the awards and stuff, Defence has more reluctance to hand over information? The clearances exist where they can, to a compartmentalised level, or?
Those members haven't been briefed into particular compartments, but they have the potential to.
Okay, thank you very much on that. When we get down to the basis of the confidence, and what this is, and my good friend Senator Fawcett here passed, I'll have to say last year now, we're in a new year, last year, a bill about the testing and evaluation process, that officers in T&E are often looking at stuff that their career paths and their officers above them are the ones putting equipment and purchases in. Are we looking at a situation here where we're asking officers whose career paths may interact with those they're looking on the awards and service history honours system, you know, they have consequence to the decision they make more so than yourselves? You have a relationship with Defence, but those in Defence have a genuine consequence potential for the decisions they make when they're looking at these things. Is that fair to say? I'll make it more basic for the troops out there. The toes you step on today are connected to the butt you've got to kiss tomorrow. Is this what we're seeing?
Okay. Perhaps I could respond to you by saying that if a serving Defence officer has nominated someone for an award and it's been rejected and they're dissatisfied, they have the legal right to seek review by the tribunal. I don't know that we've ever had anyone who had the intestinal fortitude, or whatever you care to call it, to challenge a superior's decision.
And I get that. I'm balancing the internal versus the external review or assessment of these claims, because we've had Senator Roberts over here talking about the current Chief of Defence Force talking about awards for previous at that higher level, and we've heard claims, you raised them yourself, about the boys' club or the cartel, I think was the words used today. Does it remove that image and potentially those things, if it is an external body or a body that isn't connected within military, if that initial phase is looked at there a little bit? What's your thoughts on that?
Look, as I said, I think the nomination function should remain within Defence, because identifying and seeking to recognise performance by people that you're leading is a core leadership function.
Right.
You have to have, I think, a process by which nominations are brought together and tested to make sure that you're not generating anomalies and inconsistencies. I think that's probably should be internal. I don't think you necessarily resolve the issue by moving it totally out of defence. There are ways that there could be a stronger safeguard against inappropriate issue, if I can use that as a neutral term. So, where it's proposed that an honour be awarded to someone of a particular rank, then there might be an extranumerary independent person who looks at it. And that could be someone who's engaged by Defence as a consultant or something like that.
So a limited place where, to protect Air Commodore blogs on an application of Rear Admiral Smith, in the future, that one could be referred up, whether it's a superior or someone in a higher up range of command, that sort of stuff where we can put that.
Well, that would be, they all go up.
Yeah.
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 In the ordinary course, they all go up.
Yeah.
Yeah.
No, but I'm saying, if I'm sitting on the board and I'm looking towards an assessments on that panel, and I'm looking at a superior, or I'm looking at a thing, there is some trepidation if I don't believe the award's merited to say no thanks very much, isn't there? You've got to be having a...
Yeah. Some people might think it's a career-limiting move. Yeah.
That's what I think. Okay. Thank you, Chair.
We'll go to Senator Darmanin and then to Senator Fawcett. And just for the information of committee members, I do intend to finish promptly at 4:30 today.
I've only got a couple
that's
of
all right, but I
questions.
just for shadow, I'll not like to keep it. I'll keep it tight.
Okay. Noting your comments around proposed reforms by Defence, I just wondered if you do, what's your view on whether any reforms to the tribunal are required, and if so, what they might be?
Yeah, look, I think there are appropriate amendments that should be made to the legislation. We've put some of those in our principal submission. For example, we don't have a purpose clause. It'd be good to have that. There's a whole range of powers to dispose of matters that you see in other tribunals that I would like. A very significant one, though, is if a medal, an honour or is withdrawn, cancelled, there is no appeal against the cancellation. But the person who's been cancelled can apply again to Defence to have that reissued, and when that's refused, they can appeal to us. That puts us in the position of reviewing a decision that's been made by the Governor-General on the recommendation of a minister. I think that's inappropriate. I think it'd be far better if where there was a proposed revocation, the person affected was told, we are minded to revoke. You have a right to apply to the tribunal within X weeks, and the tribunal can then look at the proposed reasons for revocation. We might say we think the revocation is singularly appropriate. The person knows that they've had an independent scrutiny over the proposed decision. We might say we don't think it's appropriate. and the Minister may accept or reject that. But I think that would be a far better way to go. So there's changes like that that you know, I would be happy to see. At the moment, people can appeal against a refusal at any time. I think going forward it would be good if people were told, you know, by defence, we're not going to recommend you. You can appeal to the tribunal, but you must lodge within 6 months, or, you know, the tribunal having a power to extend that period in exceptional cases. But I think that'd be a good advance. There's things like that.
Yeah.
But I don't think that stripping people of rights of review, curtailing their rights or abolishing their rights is a good proposal, and that's the nub of what the defence has proposed.
And just in terms of time frames, do you think there should be a time limit on how far back reviews can go? You know, for example, you know, verifying offence becomes more difficult the further back.
Okay. So at the moment, people can come to us for service going back to the beginning of World War II. It's a long time.
Yeah.
A previously constituted tribunal recommended that the book should be closed on World War II after a transition period because of the perceived difficulty in obtaining reliable evidence. I mean, you're going to be hard-pressed to get eyewitnesses. That was agreed by the then Minister. It didn't proceed. Elections got in the way and so on. They tend to do that. I wouldn't oppose that sort of a limitation so long as there was a reasonable transitional period, just like an auctioneer says, going once, going twice, going 3 times.
Yeah.
Just like the bartender says, you know, last round.
Yeah.
To let people who have a case come forward.
Yeah.
But that issue with ability to find relevant evidence, it's an issue with World War II. It's probably an issue with Korea. Certainly not an issue with Vietnam or anything since. Whereas defence would, their proposals would cut out defence, cut out Vietnam, cut out all the other campaigns and in between time. They would limit people to go to service going back 20 years, and we think that's just inappropriate. Most of the applications we get relate to service more than 20 years old, and there's lots of reasons for that. A lot of people don't start thinking about medals until they've left the service and they're reflecting on what they've done, or they weren't prepared to rock the boat while they were still serving, or they may have mental health issues that you know, surface late in life, and that, you know, where recognition becomes a big issue. It may be the family that's seeking recognition for a now deceased member who didn't talk about service, and so on. There's lots of reasons why people come to us, you know, 20 or more years. If those amendments going, you know, cutting out World War II weren't made, it wouldn't fuss me. If we can't find the evidence, we're not going to recommend the issue of an honour or award. It's a sort of self-enforcing rule in any event.
Thank you.
Senator
Thanks,
Darmanin.
Chair. Yeah.
Senator Fawcett.
Yeah, thank you. Given the time, I'm just going to ask you to take this one notice. You're one of the first groups I have come across in Senate evidence who has actually identified potential legislative reforms. Most groups just assume the law is immovable and ignore the fact that the purpose of the Parliament is to make laws. So thank you for suggesting legislative reform. I'd ask you to go a step further, though, in your role as the Tribunal, because the reform you have suggested is just about the operations of the Tribunal. You made the comment before that you do all the law requires of you, and clearly you operate within the constraints of what the rules, regulations, protocols that are in place for Defence Force members are. Have you come across cases or a consistent run of cases where you go, any reasonable person would say this particular regulation or approach by Defence is unreasonable, but we must find this way because that's what the regulations are? And can you consider that and come back to us if there are any changes that you think we should be recommending to the government, that the government recommends to the Governor-General, that things change?
Yeah, look, I can certainly give you something about that. There is one category of case where we did recommend a change to the law and the Minister didn't agree with us. But yeah, look, basically it's not for us to go setting the law. We're bound to implement the law as it is at the time of the Defence decision that we're reviewing.
I understand that, but you are uniquely in a position to observe the impact and to weigh up the reasonable person's assessment of, is this fair and logical? And to say, if you have the opportunity, this would be a change that would make sense.
Yeah, let us take that on notice, and I'll go away and lose some sleep and talk to my colleagues and so on.
Terrific, thank you.
That was also the Fawcett. Last call. We could have
One more question.
Yeah, one more question, and then if it's all right with you, Senator Roberts, we'll wrap it up after that. Thank you. Go ahead.
Mr. Skehill, it's what does it mean to you, or does it send you any signals that 4 years after the Burton report, with all of the hurt that it caused, only one war crime charge has been laid and 0 guilty convictions despite $100 million spent at the Office of the Special Investigator?
I simply cannot comment on that, Senator. I do not have any visibility of the processes and what's happening, so I just cannot respond.
Not even on the initial call for handing back 3,000 medals?
I cannot comment on that.
Okay. No, that's fine. Thank you.
Can I just comment on my respect for the things you haven't commented on today for the rule of law and your scope of what you are still do and may be asked to do? I think it's been very well done.
Yeah, I'd second that.
Yep.
Thank you.
Well, with that praise, that will conclude today's hearing. Thank you for appearing as a witness today, Mr. Skehill and Mr. Kopplemann. Thank you also for your detailed submission. I believe you have taken one question on notice. We would appreciate if a response to that question could be provided by the 17th of February, so in 10 days' time, Monday week.
Oh, you're a hard taskmaster.
And then that concludes today's hearing. Thank you to all the witnesses who appeared, to Hansard and Broadcasting for their assistance, and to the Secretariat for all the support and preparations for the day. And the committee now stands adjourned.